heard at God Save the United States of America, State of Florida, and Ms. Arnold. Please be seated.
Good morning. Morning and welcome to the 5th District Court of Appeal. As the Marshal said, I'm Judge Orfinger, and I'm joined on the panel today by Judge Torpy and Judge Jacobus. We have 4 civil matters set for oral argument this morning and then a hearing. I anticipate we'll take up the first 2 cases, probably take a break after the first 2 and ask the lawyers or invite the lawyers to join us for coffee if they choose to. If you have a cell phone, we would appreciate it if you would silence it so it's not interrupting anyone. And if you are the appellant and wish to save some time, or if there's a cross appeal and you wish to save some time, please let me know and I will set the clock accordingly. So with that, we'll go ahead and start with the first case, Mix versus Adventist Health System.
Good morning. Good morning. Mark Morsch for the appellant, Cross Appellee, Jim Mix, and the estate of Arlene Mix. I'm going to go over briefly the facts of the case, Your Honors. I know that you're familiar with the facts of the case, but the facts are important to one of the key issues or critical issues on appeal. I'm going to try to be brief on that. Your Honor, I would request to reserve, I think I have 15 minutes, so 2 minutes for rebuttal, since there is a cross appeal here.
Okay. You've got 20 minutes, and you can split it up any way you want.
15 and 20, if that would be all right.
15 and
5, excuse me.
Okay.
If I may, for rebuttal. Briefly, this case involved a patient who underwent a bypass at Florida Hospital in Orlando on Mother's Day in 2001. As a result of the surgery, the surgeon nicked her liver. She bled out over 3 days. She was desperately ill. She was letting the nurses and the doctors know that she had a serious problem. They either ignored or overlooked her cries for help. She suffered, after 3 days of internal bleeding, she suffered a pulmonary.
On your first issue on appeal, which has to do with the good faith,
yes, sir.
Is that an issue for us, or is that an issue for the trial court?
It's an issue for the trial court, Judge Torpy, because the court is required, if I understand the case law, to conduct an evidentiary hearing and to allow evidence to be given to determine whether the offer was bona fide, whether it was made in good faith. The court did not conduct such an evidentiary hearing in this case. So just on that point alone, it must be remanded, and the court must conduct respectfully a full evidentiary hearing, allowing both sides to present evidence as to whether or not the $500 offered for a brain-damaged plaintiff was bona fide. That's the first issue.
But if they've evaluated the case and concluded that for whatever reason it's a no liability case, and they ultimately are proven to be correct, doesn't that tell us something?
Your Honor, if I could cite to the Good versus Udawani case, there was some good language in that case, I think, that addresses this issue. Trial courts should view with considerable skepticism nominal offers which bear no reasonable relationship to damages and which are not founded upon a reasonable and realistic assessment of liability. Such nominal offers cannot advance the statutory purpose of encouraging settlement, but instead serve no purpose other than to lay a predicate for the subsequent award of attorney's fees as occurred here. I would suggest that a $500 offer to a brain-damaged plaintiff who suffered a clear liability injury in a medical malpractice case, where the evidence shows that for 3 days she cried out to the nurses for help and the hospital staff and was ignored, was allowed to literally bleed to death, was revived, had 3 liters of blood in her belly after 3 days of bleeding. I think a $500.
Well, it could be good faith. I thought you just acknowledged that this is an issue for the trial judge, right? I mean,
well, obviously,
or are you asking us to hold that as a matter of law when the damages are just so catastrophic that any offer, irrespective of what the thought process is bad faith?
Judge Torpy, I cannot do that because this court hasn't held an evidentiary hearing. So I guess I'm just arguing my fervent position on good on
right,
whether
if we remand it, you get your evidentiary hearing, it's abuse of discretion on further review, right? I mean,
this court can do nothing else respectfully. The other reason you should remand it for an evidentiary hearing is because of entitlement. Because of allocation. That's the second issue. Allocation in this case, the hospital came in at a hearing without forewarning and gave the court a final judgment, which made Mr. Mix, who had a consortium claim, responsible for the full $250,000 in fees and costs. He had a consortium claim which the hospital may have spent $1,000 defending. There was no attempt by the court to hold an evidentiary hearing to allocate the $250,000 that the hospital was seeking.
Was there any objection? How was that issue preserved?
Yes, sir, it was preserved. That's one of the issues the cross appeal raised. If I can draw the court's attention to the hearing transcript, which is in my brief, I was concerned. I got to see the final judgment at a hearing on an equitable lien. What happened is we had a hearing initially on whether or not the hospital was entitled to even have a claim for cost and fees. That was held, and then subsequently the court held a hearing when the hospital filed a motion for equitable lien. So we went to the hearing on the motion for equitable lien. The court denied that. At the end of that hearing, the hospital presented a second amended judgment, which I had never seen before the hearing. And at that point...
The equitable lien was for attorney fees, right? They wanted a lien against the other proceeds.
Yes, sir. There was $3.1 million coming to the plaintiff from the co-defendants, and they wanted to get their hands on that money before it was spent.
But you all agreed, I think, if I read it correctly, you all agreed to the amount of the fees.
Correct.
They were reasonable, right?
Correct.
There was no dispute about that.
Correct. Correct. I stipulated, I think, to $225,000. I thought what the hospital was seeking was reasonable,
Right.
but I did dispute entitlement and allocation. And
How
Judge,
it got allocated between the the defendants.
Yes,
the
sir.
Two claims.
Yes, sir. And let me tell you why that's, and I want to go back to Judge Orfinger's question because I haven't answered it, Judge, but I was concerned. I didn't really have a chance to review the second amended final judgment. I was still concerned about entitlement, and I said to Judge Turner, I'm concerned that I'm going to waive some privilege before the 5th District, and he assured
He said,
me.
no, I'll make it clear on the record.
He said, you've got every issue you want to raise on
Judges
appeal.
do that? I mean, can trial judges do that?
He did that.
I know, but I mean, does that preserve it if they say so? Or
Well, I mean, I relied on that. I would have gone further to make my arguments in the trial court. I was concerned about both allocation and entitlement, and Judge Turner assured me I had all of my rights and privileges and attendant thereto on appeal, so I relied on that.
What's your best argument on your contention that the offers were ambiguous?
I don't know that I can say the offers were ambiguous. I think you're talking about the particularity requirement of Rule 1.442.
for non-monetary.
Yes, sir. The non-monetary terms, I think that this court actually had a case out of the 5th that went up to the Supreme Court talking about that. And the citation escapes me, but you're familiar with the case?
Nichols.
Yes, Nichols. And I think this court actually said, look, you've either got to attach the release or you've got to state with particularity under Rule 1.442 the content and substance of your non-monetary terms.
In this case, they didn't attach the release, right?
They did not attach the release, nor did they state with any particularity other than beyond broad language what the release requirements of the non-monetary terms were.
Doesn't that kind of make it not kind of ambiguous within Nichols, or no?
It means, yes, it violates, I think, the particularity requirements outlined in Rule 1.442. Yes, ambiguous. Yes, it's ambiguous. It's not bona fide. It's not in good faith, and it was illegally allocated, in my opinion.
Well, what the Supreme said was that it has to eliminate any reasonable ambiguity about its scope. That's your position.
Yes, sir. And the rationale is that a layperson, even though they have an attorney, shouldn't have to seek court input to determine the particularities of the non-monetary terms of the offer.
Well, a lot of times these releases are draconian. They have all kinds of indemnification and things like that you don't expect, so you got to come back to court. That's kind of the reason for it, I think.
Sounds like Judge Jacobus is agreeing with you on that point. So,
Yes, sir.
yeah,
Yes, sir.
I wouldn't argue with him if I was you.
Well, I'm not sure I need to argue about anything. I'm not sure I know what I'm talking about. But my last comment would be this, and that is only back to the bona fide, because that is sticking in my throat, and I know this court can't decide that. But a bona fide offer of judgment should be sufficient to
Well,
cause.
I mean, you can't evaluate something, it gets sticky, as Judge Torley pointed out, if you got huge damages, but sometimes there's just no liability. I mean,
Correct.
To a particular defendant.
And I think that's the hospital's
And
position.
so that's always in the equation. I think that's a difficult thing for plaintiffs to understand, but, I mean, so it can be that way. And it turns out they were right.
And I certainly think that's the hospital's position taken in good faith on their part, is that, look, there's no liability, we're sorry for her injuries, here's $500. So I think that the main thing, Your Honors, I would ask the court to do
Evidently,
is,
the liability was somewhere else, correct?
I think that the jury found liability on the surgeon who lacerated the liver during the bypass. And the jury found zero liability on the hospital. So in looking into the future crystal ball,
Well, I know.
the jury agreed with the hospital on their assessment. I do respectfully believe this court should remand it, though, for an evidentiary hearing to determine both entitlement and allocation, and that's what I would ask you to do. Thank you very much.
Thank you, sir. Would you like to reserve any time for rebuttal on your cross appeal?
Your Honors, I sure will take 5 minutes. I doubt we're going to get there. And we have some issues regarding the appeal that is traveling with this one that none of us have
Mr. Black,
requested.
are you Mr. Black?
No, I'm sorry, Chuck Ingram for Florida Hospital. Adventist
You know, I
Health.
always get criticized by my colleagues when I interpose questions before the lawyer gives his name. So I wanted to make sure I got your name before I asked you a question.
Thank you, sir. Chuck Ingram on behalf of Florida Hospital.
Let me ask you a question,
Yes,
all
sir.
right? Let me zero you in on the proposal itself.
Yes, sir.
And in particular, these two documents that the defense lawyer was going to draft up and send over after the proposal was accepted.
Yes, sir.
Okay. Now, I know number 2 is a joint stipulation for dismissal with prejudice.
Yes, sir.
I think I know what that is. That says you can't sue me again for anything you already sued me for or anything you could have sued me for in connection with this transaction, right?
Well, I believe it's more, we're dismissing this case against you with prejudice.
If you dismiss a case, it's res judicata as to any compulsory claims, right?
Yes, sir.
Okay. All right, so what does the number 1 add to that? What does that do?
Arguably, it doesn't add anything.
Doesn't add anything. Why'd you put it in there?
Historically, we have always asked for a release, and there is, it
And
doesn't,
historically, you push a button on your word processor, and it cranks out what? Is it a 1-sentence release, a
We use the-
1-paragraph release, a 1-page release, a 2-page release, or a 10-page release?
I believe it's 4. It's
4
the one-
pages.
It's the one from the
And
Florida trial
these
lawyers.
folks are supposed to guess, I guess, about what it's going to say, right? They have to accept the proposal in the dark and guess what these 4 pages are going to say when they get them, right?
Yes, sir.
Yeah, I think that's what Supreme Court said, you know, when they said that if you agree that you didn't attach the release.
Yes, sir, we
summary.
did not.
They said that the summary has to eliminate any reasonable ambiguity about its scope. How can you eliminate any reasonable ambiguity about the scope of the release when the only thing you say is they got to release all claims?
In this case, against these parties.
That's not what it says. Number 1 says release of all claims as to the defendant
Yes.
making this proposal. It doesn't say release all claims that arise from this lawsuit, does it?
It says all claims against this defendant, Your Honor.
Yeah, I mean, that could be anything. I mean, they could have had a...
But they
you know,
didn't.
Well, that's all well and good, okay? But, you know, they got to go then clarify with you, what are you asking about here? And if they have to clarify, Supreme Court says, you know, it's an invalid offer, right?
Respectfully, I don't believe
I know that
that's
you
what-
always respect the courts, or you don't have to say that.
That's not what I believe the Supreme Court said in Nichols.
Well, what else is in it? I appreciate your candor on the 4 pages. You know, my colleagues and I have seen a lot of releases over the years, and I think Judge Jacobus said some of them can be draconian. What was going to be in the 4 pages of this release that you had in your mind besides, you know, what you said in paragraph 1 here?
It says you release us and our employees. It says you and our officers. It says that as the
Does it say you're going to indemnify us if,
No,
you know,
sir.
if we get sued when we're not supposed to
It
be
says
sued?
that I'm sorry, excuse me.
No, go ahead. I mean,
As in the line prior to that in the proposal, it says you will satisfy all liens, which has been approved by the courts, as you don't have to list every lien that they're going to be responding to. It then says that each party will bear their own attorney's fees, and it says that we don't make any representations regarding the tax consequences of this settlement. It's the one that's put out by the Florida Bar Trial Lawyers section. And
Let me tell you another concern that I
Yes,
have.
sir.
In the body of the proposal for settlement, you indicate that it's intended to settle any and all claims of any type which were or could have been made against the hospital.
yes, sir.
In paragraph 1, you say release of all claims, and all claims in paragraph 1 is a capitalized term, which in normal drafting, when you capitalize an ordinary word, it generally means it's been given some specific rather than some generic meaning. In the body, the word all claims is not capitalized and not defined. In paragraph 1, all claims is a capitalized term, which generally means we've defined it somehow. And I think when most lawyers draft documents, if you're going to give it something other than just an ordinary meaning, you would define it someplace. All claims means whatever. You can define it any way you want. But I'm a little bit concerned too that a reader wouldn't necessarily know what all claims were. As Judge Torpy points out, if Mr. Mix had fallen in the hospital 2 weeks before, completely unrelated, I think that language is susceptible to saying that he would be releasing his slip and fall claim.
It would, if there was one in existence, but there wasn't.
But as the proponent of the settlement, isn't it, or as the proponent of the offer, isn't it your obligation to remove any reasonable ambiguity by either attaching it, which is the easiest thing to do, so that nobody's guessing. We don't have this conversation if you attached it.
Well, we have a different discussion where they nitpick every section of the release, which
They
is
can
the rest
reject
of the
it.
case.
They can just say, we're not willing to sign that release. They reject it.
Or they, as in the carry-all case, in the several of the cases, they look at it and say, well, here you said employees, and we've already dismissed one of your employees, so that, as the carry-all case said, now they're trying to nitpick the release that you did send them. Saying that the release itself created the ambiguities. And that's where we kind of get whipsawed. They say you've created an ambiguity by not attaching a release. You might ask for things you didn't ask for, but now you say when you do attach the release, as in the carry-all case, they say, well, now you're asking, here's the 4-page release, and it has the language that says, I'm releasing you and your employees. Well, even though I already dismissed your employee, now you bring him back in, and now this is a joint proposal for settlement, and it's unfair.
that kind of gets back to your first, the first answer you gave me to the first question is, why do you even need a release? And your candid answer was, you don't.
You're right, sir. We don't use them anymore.
We give you the money, you dismiss with prejudice, and we all go about our business. But the trouble comes in is that when you start asking for things that are going to be drafted in the future, the rule says you got to do it with particularity. I think that means what it says,
I understand where the court is coming from, but respectfully, and again, I apologize for
It's okay.
it's an old habit. Got in trouble for saying Your Honor to the lady.
It's your job to disagree with it. Yeah.
As Judge Orfinger pointed out, paragraph 1 of the proposal says all claims as to this defendant. I believe words to that effect.
Well, it says the claims that were made or could have been made. So there you're getting, there you're getting into your essentially your dismissal with prejudice issue.
Yes.
Which is essentially redundant with number 2. But then you got this number 1 in there, and you got to. I mean, I look at it. I say to myself, What are they getting at there with that? They got a dismissal with prejudice of everything that was made or could have been made. So why do they have this in there? And then you got to speculate about what this document's going to look like and what it's going to say after you accept the proposal. I mean, you're stuck with it, right? You can't go into the trial judge after you've accepted this proposal and say, oh, I didn't know that the release was going to say this and that, right? I mean, you're going to lose on that argument.
I don't know that you would, but it didn't happen in this case because they never accepted anything.
But that was the point the Supreme Court made, is that offers of settlement and proposals for settlement should eliminate any further judicial labor, not get us into another, whole can of worms, which is whether or not the tendered release is consistent with the proposal, right? I mean,
having been involved in 18 months of litigation since the judgment, I'm not sure that having attached a release to this proposal would have made any difference. I believe that Mr. Morsch, doing his job, would have attempted to find an ambiguity within the release.
Well, he was riding on that it wasn't a good faith offer, I think, but,
what about that? What about the good faith offer? Why don't you talk about that?
Your Honor, we were 18 months into the litigation. The proposal for settlement came 2 days. During that 18 months, there were about 13 depositions of all the health care providers involved, both plaintiffs, because Mrs. Mix was alive at the time. The proposal for settlement came 2 days after plaintiff's medical expert criticized the surgeons and made the comment that he would voice no criticism against the nursing staff.
Is he entitled to I think he acknowledges that this could go either way at a hearing. Is he entitled to a hearing, Phil?
He's entitled to a hearing, which he got. He's not entitled to an evidentiary hearing. I don't know what evidence the court would look at other than the record and the trial court having lived through the case and the trial.
Well, how do you tell whether somebody acted in good faith or not unless you kind of get into their head and find out what their thought process was, or at least what the evidence was that they had at the time they made the offer?
That's what you look at. What was there in the file? What was there in the court? What was there at the time this was done? And you can look at the result. You look at any reasonable basis for making the offer that was made.
Did he ask for an evidentiary hearing on that issue?
No, sir. We had 3 hearings on the fee or the proposal for settlement. At no time was there ever no one asked for an evidentiary hearing. I don't know who you would ask for evidence from. I guess he could have deposed me and had me offer testimony as to what my basis was when we made it. We put all of this in the record. Judge Turner, the trial judge, heard the evidence at trial, heard the witnesses at trial. He did have, because we had gone through pre-suit, we did know he had a nursing expert. We knew she had been a nurse for approximately 1 to 2 years at the time the alleged negligence had occurred, that the nurse she was criticizing had approximately 15 years more experience than she did, that there were a lot of things we knew about his expert, including the fact that her mother was Mr. Morsch's office assistant of some sort. And I'm not positive we knew that at the time we made the proposal. That came out in her deposition. But having their medical expert make a on-the-record statement that he would voice no criticism, we attached the letter from my partner that accompanied the proposal for settlement. That was attached to Judge Turner, or one of the earlier memorandum of law, where we offered it to Mr. Morsch that if he would dismiss the case, we would go away with no fees. And then we offered the proposal for settlement that his expert hadn't criticized us, and before a nursing expert came forward with criticism, he might want to consider dismissing what we considered to be a weak case against the hospital. Judge Turner sat through 2.5 weeks of trial and agreed with us that we had shown at the time the proposal was made After 18 months of discovery, plaintiff had noticed the case for trial. The case had been set for trial, so this wasn't early in the process. This was well into the process. We then had a long delay when Mrs. Mix passed away from unrelated causes, but that delayed us getting to trial, but had nothing really to do with the proposal. But I just don't, no one ever asked for an evidentiary hearing, and I don't frankly know what evidence that wouldn't be totally self-serving, subjective evidence. You know, we have the record, we know what had happened, we know what people argued, but other than saying that again, I just don't I don't see that as being an evidentiary issue. I believe it's a trial record.
Let me take you back to the summary thing, because I forgot to ask you one thing.
Yes, sir.
Did you look at Nichols?
Yes, sir.
How, you know, in that case, the Supreme Court said that the summary was not particular enough. How did the summary, or how did the release language in that case differ from what you have here?
I didn't look at the exact release language. What I saw...
They didn't have a release in Nichols. I
didn't
recall
look
that, but they said that a release would be a condition,
Yes, sir.
that would be drafted, and I'm just wondering whether it was the same language or different. You don't remember? I'll look at it.
I didn't see a specific summary in Nichols. What I saw was them saying there were two claims at the time of the case. Mm-hmm. There was a PIP claim and a UM claim, and the language that they talked about, as Judge Orfinger alluded to, settling all claims. It's not a maybe Mr. Mix had fallen at the hospital in the interim, but there was no case. Second case.
Nichols didn't turn on whether or not there was actually another case out there. That just was used as an example to point out that, you know, that the release has got to be clear, right?
I think it comes down to the fact that there was a totally separate claim.
So we got to have an evidentiary hearing to find out whether there was another claim out there to decide whether or not.
Well, there's no need for an evidentiary claim. In Nichols, there was another claim. In every one of those cases, there is another claim.
And there's no other claim here, right?
Excuse me?
No other claim here.
There is no other claim.
Right. And we know that because we asked, or what?
We know that because it's been 10 years and there's never been another claim.
Okay.
Should the attorney fees be allocated between the claims?
That was never asked for. None of the cases.
You don't think it's a preservation issue as far as you're concerned?
It's a preservation issue. It was never asked for. Mr. Morsch, we handed him the judgment and the order. He agreed. He said, I'm expressly preserving my right to contest entitlement, but the language of the order and the judgment are fine. So he didn't preserve it. It's the exact same language in his order against the doctor. There is no allocation of the claims. There was no allocation of the claims at trial. There was no allocation of attorney fees. Every case that has been cited, there are issues of allocation because there are some claims. In one of the cases, there's insurance coverage that there would be fees for, and a tort claim that there would not be fees for, or appellate fees that were awardable and underlying fees that were not. In this case, just as the plaintiff's judgment against the doctor and his professional association was unallocated in his judgment, our judgment for costs and fees, I think we ended up getting a final judgment, then a first amended final judgment with costs, and then a second amended final judgment with adding the fees. There was never an objection to any of those, the language of any of the three of the judgments. It was just never raised until the appeal came up. I'll reserve my minute and 42 in case we want to talk about the probate issues, and I don't know that that's a proper, but we are prepared if it's necessary.
Your Honors, I can't offer anything further to elucidate the court. Thank you.
Sir, thank you.
Thank you, Mr. Moore.
All right, thank you both.